Hello, can everybody hear me?
Oh, hi. Yeah, we can. I can hear you.
Perfect. Um, we will begin shortly. We're just waiting to see if we have another judge joining us. So if you could just bear with us just for a couple of minutes. But I am conscious of the time that has been allotted. So we will get on as soon as we can. In the meantime, if we can just make sure that all counsel are here, your co-counsel, and that you are all set up in terms of being able to hear and see properly with your video, so that we don't have any problems in terms of technicality when we do start.
Yeah, sure. My junior counsel will be joining in a couple of minutes.
Okay, that's fine. We will wait for them to join. I'm just seeing a message from, forgive me if I'm not pronouncing your name correctly, Ines. You're not able to connect via audio. Perhaps if you would like to sort of leave and rejoin, I don't know if that might fix it. Are all counsel now present? So does everybody have their full team and co-counsel here on this meeting?
Yes, ma'am. Middlesex Team J, Senior Appellant and Junior Appellant is here.
And ma'am, for the
Excellent,
University of
thank you.
Bolton, I'm sorry.
Yes.
For the University of Bolton Academic Center, both the counselors present here.
Excellent. Thank you very much for confirming that. If you just bear with me a minute, I'm just going to see if we're going to have another judge attending, and if not, we will proceed with the hearing, and I will hear all the submissions from both parties. So if you just bear with me. Right, we will make a start. I'm conscious we are 5 minutes into the allocated time we have to hear this hearing. If I could have all parties come on video and just introduce yourselves and which parties or which party you represent and your name, just so I can take a note of that before we actually begin with the substantive hearing, please. So we'll start with the appellants team. So that's Middlesex University. So if I could have both counsel just come on video, please.
I'm just waiting on Henna.
Right.
Can
Ria,
you see me?
who do you, what's your role?
I'm the junior appellant and Henna is the senior appellant.
Right. Thank you. And if in a similar fashion, if I could have the team for the respondents, so the University of Bolton, if you could both counsel just come on video so I can identify your respective roles, please.
Okay, ma'am. Myself is Fatima. I'm the senior respondent, and my co-counsel Inas, she'll be the junior respondent.
Right. Thank you both. I'd like to invite now the appellants' counsels to proceed with their grounds and their submissions. So if you could come on video and we can make a start.
Am I being audible?
Yes, you are. I can hear and I can see you, so we're off to a good start.
Oh, all right. Thank you so much. If I may please the court, my name is Henna Babu and I represent the appellant, Mr. Ray Spain. Before I present my submission for the benefit of the Lordship, I may brief the case. Clevity is a digital platform on which users can create an account and trade in cryptocurrency. The platform's distributed ledger is distributed across various countries across the globe, and one such node is based on the server within Dubai. According to the conditions laid down by the program, the ledger is distributed, and one such node is based. According to the conditions, the users must maintain at least US 50,000 as the cash margin in their accounts. My party, Mr. Ray Payne, is a user on the Clevity platform along with the respondent, Ms. Rajrani. The appellant program is called Beta, whereas the respondent's name is Alpha. According to the facts, Mr. Payne's program is programmed in such a way that if there is no users offering to sell Yapple, which is the cryptocurrency, then Beta will automatically offer Yapple for a sale at the higher price. Now, coming to the timeline. According to the timeline, on the 10th June 2022, there was a routine upgrade as a result which an error occurred, leading Beta to automatically offer to sell Yapple at its default price, followed by Alpha agreeing to buy. Since 30 minutes before the upgrade, the parties were the only ones permitted to trade according to the terms and conditions laid down by the program. The issue occurred when both the parties concluded the trade automatically. My lord, it is to be brought to notice that without human intervention, since both the parties were asleep. Subsequently, our respondent, Ms. Razani, issued the proceedings in the DIC court. Your Lordship, today I would like to cover two main points. First, Article 5, A, subsection 1, subsection B of the Judicial Authority Law, which does not apply in the favor, and second point being the DIC courts having no jurisdictions in this case. My lord, it is to be brought to notice that the first instance court did err in concluding that the DIFC court has jurisdiction over the claim under Article 5, Section A, subsection B, 1B of the Judicial Authority Law. My lord, we strongly believe that the DIFC court does not have the jurisdiction over the claim. The above article of the Judicial Authority Law states that the court of first instance shall have exclusive jurisdiction to hear and determine civil or commercial claims and the actions arising out of or relating to a contract or promised contract, whether partly or wholly concluded, finalized, or performed within the DIFC, or will be performed or is to be supposed to be performed within the DIFC, pursuant to express or implied terms stipulated in the contract. My Lordship, as the fact stated, the program has multiple ledger notes across the globe. Therefore, it also has a ledger note in Dubai, UAE, but specifically not in the DIFC. My Lordship, with your permission, may I present to you my first submission? With the support of the case law of Alibaba Group Holding Limited and Alibaba Coin Foundation 2018, I would like to make my first submission. My Lordship, would you like to hear the brief of the case facts?
Yes, please, counsel. Do address me on the facts of that particular authority.
Yes. The case involves the Chinese e-commerce giant Alibaba Group Holding Limited issuing proceedings in the US court barring the Dubai-based cryptocurrency firm Alibaba Coin Foundation from using the Alibaba name. The Honorable US Judge Paul Odkin in the Manhattan Federal Court issued a preliminary injunction stating that the Manhattan court lacked the jurisdiction even after the e-commerce giant Alibaba produced evidence stating that at least one Alibaba coin investor was in New York or was based in New York. It was held that the transaction occurs in the place where where there is a change in a ledger, the place that the ledger takes place. So according to our case fact, there is a ledger note in the Dubai, but it does not mention that the transaction took place in the jurisdiction of Dubai or of the IFC. We do not have enough materials and facts supporting the accuracy of the location of the transaction. Since the blockchain involves numerous nodes located in different jurisdictions, it is difficult to determine the exact location and hence can lead to completely different and conflicting legal frameworks. My following submission involves using the case law of Iron Science Limited and Duncan Jones, along with Persons Unknown, Binance Holdings Limited, and Payward Limited 2020. For the benefit of the court and the lordship, I may brief the case. The Iron Science Limited and Duncan Jones Persons Unknown, Binance Holding Limited, and Payward Limited 2020, the applicants alleged that as a part of a fraud, the first respondent induced the applicants to invest about 577,000 pounds, which equated to 64 bitcoins, which in today's market is very expensive, into various cryptocurrency investment opportunities. The first respondent had stated that the investments had proved to be a success, but unfortunately, there were no initial investment sums or profits which has been returned to the applicants. The applicants sought to various forms of relief from the court on an urgent ex parte application for which permission to serve out the jurisdiction and by alternate means was one of the forms. The case law mentioned is indeed a significant case in today's jurisdiction, particularly because it was the first ever case in which the court had granted permission to serve a freestanding banker's trust order out of the jurisdiction against the cryptocurrency. Therefore, my lordship, we can conclude that the English court in the above case proceeded on the basis that the territorial jurisdiction was based on the place where the person who owns the asset is domiciled. In our scenario, both the parties were not domiciled in the DIFC court. My lordship, the DIFC court does not have jurisdiction over the case according to the law number 10 of 2005, part 5, section 15, subsection 2, which glorifies that where the property is in transit or its location is unknown, the validity of the transfer is governed by the law governing that transfer. In such a scenario, according to our case facts, we are neither unable to pinpoint a certain location where the transaction took place, nor conclude that it was within the jurisdiction of the DIFC court. The statute above mentioned can be further supported by the case law of Russian Cryptopia Limited, 2020, which states that cryptocurrency in today is also a form of property which are capable of being held as a trust. My Lordship, with that, I conclude my arguments and I would request you to find in favor of my client, Mr. Leithpain. Unless the court requires my assistance further, these are my submissions. Thank you.
Thank you, counsel. I do have a question for you. So you've addressed me on the jurisdiction ground. Just in relation to that, you say that the court can't be sure that the transaction itself took place on the node, as it were, that was located in the DIFC, so as to allow the DIFC to have jurisdiction over this matter. You say that there just isn't enough information about where it took place, given that there are several nodes, or many hundreds perhaps, in relation to the way the ledger system works. Yeah. So could you assist me in the court that if the DIFC is not the correct jurisdiction to hear this matter, how should the court go about trying to decipher which jurisdiction is the correct one if this isn't? Because my understanding is that one of the nodes was located in the DIFC.
Even though one node is located, according to my one of the case laws that I used as my supporting, if you can I look at the case name, please?
Yes, was that Alibaba, I think?
No, the Alibaba was in regards to the case for sure, but the Iron Science Limited and Duncan Jones, that particular case talks about the jurisdiction, territorial jurisdiction, and it was held in the English court that the territorial jurisdiction was based on the place where the person who owns the asset is domiciled. Now, according to our case facts, both our parties are in two different jurisdictions. I believe my party is from Muscat Sultanate of Oman.
Yes, so that's correct.
Scenario, yeah. So in that scenario, I would request the court, the proceeding should be held in one of the places where the parties are domiciled. Therefore, the DRC will not have. Sorry.
And on that basis, that you say your submission is that the correct jurisdiction is based on where the parties are domiciled, and in your case, it's where your client is in Oman would be the correct jurisdiction to hear this matter. On that basis, if we are, as in your submission, the court is to look at this in terms of where the parties are domiciled, what is your submission in terms of persuading me that Oman is the correct jurisdiction as opposed to where Miss Rani is domiciled? Because if I'm to look at where the parties are domiciled, where they reside, why should I find in favour of the jurisdiction in which Mr. Payne resides?
Because Ms. Rani is the one who raised the issuing. She raised the proceedings.
So on that basis, counsel, should I go with where Miss Rani is domiciled? Because in effect, this is her claim and she is enforcing her rights to have this matter resolved. And Mr. Payne is simply defending a matter.
For my party, I would say it would be favorable if it is proceeded in his jurisdiction, which is Sultanate of Oman.
Okay, thank you, counsel. Do you have any further submissions?
No, I do not have any more submissions. Thank you.
Thank you. So we can proceed then with your co-counsel and the remaining submissions that the appellant wishes to make, please.
Hello, can you hear me? Am I audible?
I can, counsel. Yes, I can hear and see you. Perfect.
Thank you. If it may please the court, my name is Ria Sehjwani and I represent the appellant, Mr. Leithpain. Your Lordship, today I would like to cover 2 points. Firstly, the reasonable man test was incorrect, and secondly, that the court made an error in judgment. The DIFC contract law, Article 37(1)(a), states that if other party made the same mistake or was mistaken or caused the mistake or knew or ought to have known about the mistake and leaving the contract was against reasonable commercial standards of fair dealing, then the mistake at the time of the contract was made so significant that a reasonable person in the same situation as the party would not have concluded it at all. In this situation, both Mr. Payne and Miss Rani were asleep when this automatic transaction took place, and Mr. Payne clearly stated that he had not made the same mistake as Miss Rani, or caused her mistake. He wasn't aware of Miss Rani's mistake, and so there were no grounds to be avoided to dispute trade. Hence, the state of mind of the programmer while designing the program should be taken into account. The Singapore International Commercial Court uses well-established contractual ideas and considers the theory of mistake while discussing automated contracts produced by computer programming and errors in cryptocurrency trading in the case of Quion Ptd Ltd and B2C2 Ltd 2020. Simon Thorley, IJ, provides crucial guidance in the B2C2 Ltd and Quion Ptd Ltd case on how to apply the law of mistake in situations where legally binding contracts were carried out by automated contracting systems without human interaction. When transactions were carried out by the computers acting as program machines, the court had to consider how to answer the question of whether the parties knew about them. The court also had to decide whether cryptocurrencies were property that could be kept in trust and what sanctions would be appropriate in the event of cryptocurrency-related contract or trust violation. The Singapore International Commercial Court uses well-established contractual ideas and considers the theory of mistake while discussing automated contracts produced by computer programming and errors in cryptocurrency trading in the case. In this instant, the issue happened when Miss Rani and Mr. Payne both were asleep, and since it was an automated settlement, it is seen as an error. To summarize, with the support of the above-mentioned authorities, the reasonable man test was incorrect and the court neglected the programmer's state of mind. My Lordship, with that, I would like to conclude my arguments, and I would request you to find it in favor of my client, Mr. Leith Payne. Unless the court requires my further assistance, these are my submissions.
Thank you, Counsel. Just picking up on your last submission there and
Yes.
your reliance on the B2C2 case, you've asked for the court to find in your client's favour, but as you mentioned, the error occurred when both parties were asleep. So help me on this. Should the court not consider the parties equally, in that in fact neither of them made a mistake here, and in fact that this was just an error that occurred on a system that they had no control over? What in particular should I bear in mind when considering this appeal about the role that your client had vis-a-vis Miss Rosie?
Okay. As per the case, just a minute. So we do need to consider both of them equally. However, Mr. Payne did state that he had not made any mistake, and even so, he hasn't really checked up if Miss Razi made a mistake in the programming. So if you were to take them both into consideration, you would have to treat them equally, but also at the same time, you would have to say check the state of mind when they were programming this program.
Thank you, Counsel.
Thank you.
Does that conclude the submissions from both counsel for the appellant?
Yes, it does.
Thank you. We can now proceed to hear from the respondents team, please.
Thank you, Madam Lordship, and may it please the court. My name is Fatima, and I, together with my co-counsel, appear for the respondent on the case Mr. Leith Payne versus Ms. Raz Rani. I'll be dealing with the law question, whereas my co-counsel will be dealing with the jurisdictional question. Shall I proceed, my Lordship?
Yes, please do proceed, Counsel. Thank you.
My lord, the facts of this case are straightforward. The evidence will show that on June 20, 2022, a software by the name of Clavity underwent a routine upgrade, which resulted to an error causing the software to wrongly exclude all the users from the market who had less than $50,000 margin as originally intended, and instead changed to a $200,000 margin. Ms. Raz Rani and Mr. Lee Payne were the only users with a margin in excess of $200,000. And so for the 30 minutes before the glitch was noticed, they were the only users permitted to trade. In the absence of any market activity, Mr. Payne's beta program automatically offered Yapple at a highly inflated price of $100 per Yapple instead of $10, which concluded to a disputed trade, prevailing the market price, which in result debited Ms. Razi's account an amount of $250,000. This all happened while they were unaware of the transaction. Now, this court should find in favor of the respondent for two reasons. First, the disputed trade was void for a unilateral mistake. Second, the court has a jurisdiction over the claim against the appellant. Shall I proceed with my issue, Your Lord?
Yes, please continue.
Seeking declaration that the disputed trade was void for the unilateral mistake, the court concludes the claim to avoid dispute trade as an error within the transaction if there was no knowledge of the circumstance. Now, when we look into the data protection law number 5 of TIFC, the goal of the above mentioned law is to establish procedures and regulate the management of personal data that both the controllers and processors collect from the data subject. Although there's no data relevant in our scenario, the legislation is nonetheless important because it aims to protect how personal data is handled. Especially Article 14, subclause 2 of the data protection law states that a controller or a processor must put in place the necessary organizational and technical measures to guarantee that the processing is carried out in accordance with the law. This includes any risk that the processing may cause. And it is clear in this problem that Mr. Payne failed to take into consideration the risks of the program and how it inflated the price by a method that take advantage of the other party involved. Now, if we cite the electronic transaction law, again, the law of TIFC law number 7 of 2017, this law is to ensure the validity of transaction made by the parties and such be able to dispute the trade in first place. And this law details usage, formations, and legality of the electronic contracts. Now, Article 16 of this law lays down the validity of electronic communication as forming a contract. It states that where an electronic communication is used in formation of a contract, that contract shall not be denied validity or enforceability solely on the ground that the electronic communication was used for that purpose. Additionally, Article 19 of this particular legislation clearly mentions that the contracts formed through the automated message systems are a valid form of contract as well, so long as said automation was started through the interaction of a natural person. Here we argue that this trade wasn't automated through a natural person interaction. Now, when we look at the data corruption of Article 9 and 16 of the Uniform Regulation of Digital Transactions, Article 9 sets out the particulars of what happens in the case of data corruption. We can apply this in our case because due to the incident which has caused this issue to occur, the transaction has been done under circumstances that have corrupted the agreement. Here we say the agreement was corrupted because there was no human interaction while the transaction was automated. Now, when we look at the cases of A versus Persons Unknown of 2019, it's an English jurisdiction case. This case sets out how define the fungible and non-identifiable crypto assets considered property that can be bought, sold, and held on a trust basis. And even the cases of Wang versus Darby and Ray Ahmed case, Europe of 2010 talks about the guiding principle of express trade in a contract. Now, Here, in the case of A versus Persons Unknown of 2019, the commercial courts granted proprietary injunctions against those who have fraudulently extracted or misappropriated traceable proceeds of digital assets. In this case, that means that Mr. Payne has misappropriated the goods through a mistake in his programming. Now, when we look at the Ray Lehman case, Brothers International case of 2010, in this case, Judge Briggs laid out the guiding principles regarding the foundations of express trust in a commercial transaction. In this case, Judge Briggs commented that the parties' commercial agreements and arrangements should be interpreted purposefully to ascertain commercial objectives. In this sense, the disputed nature of the transaction calls into question whether the trust was valid in the first place, despite a transaction being made by Ms. and here Ms. Razi was unsatisfied with the result, and such could constitute the commercial objective being unfulfilled here. Now, when we look into the Forest DFS Australia Private Limited Mr. Manival case, it's again a cryptocurrency where Crypto.com is a cryptocurrency trading platform. And in May 2021, accidentally Forest DFS Australia transferred a total of Australian dollars 10.5 million to an Australian woman, Deva Manohari Maniwal. This was due to an error in the processing of a refund, which was originally just 100 Australian dollars. The problem was supposed to be a human error, with the account of Maniwal being inputted into the payment amount field instead. This error was noted 7 months later the following December, and this time though the money has already been used in several transactions, purchase and lending, etc. The presiding judge of Victoria Supreme Court, Judge Elliott, had given a judgment against Ms. Maniwal after the operating company Forest DFS Australia Private Limited had acted against a mistaken payment. And in this particular case, the judge had ordered Ms. Maniwal to pay Australian dollars 1.35 million and held that the property was acquired in trust for forest, which was bought for money that has been accidentally transferred. This case is directly related to our case because here the judge of Victoria Supreme Court held that Ms. Maniwal should pay back on the basis that it was a human error. And here in our case, we do believe that even though there was a glitch happened and there was a routine upgrade and there was a glitch, and that only there was a shift in the minimum balance requirement. The issue is with the inflation of the price, and that is due to the way Ms. Lead Payne has structured his program beta. And we strongly believe that on this ground, this trade is disputable and void under this legislation. And if you have no further questions, these are my submissions, Your Lordship.
Thank you, Counsel. Just assist me on this. Why is it that the court should consider that there's been a unilateral mistake on the part of the appellant, Mr. Payne? What in particular is it that I should be considering in relation to his conduct? My view, Counsel, is that this was a trading platform, but both parties came to in sort of equal measure. I'm not clear on what particular unilateral mistake Mr. Payne has made here. And I know that you mentioned, in reliance on the authorities that you've drawn my attention to, that Mr. Payne has misappropriated in virtue of that unilateral mistake. So just take me a little further on that, if you would.
Yes, you are, Madam Lordship. We believe that this is a unilateral mistake from the part of Mr. Payne, because here there was a routine upgrade went through the Clarity platform. Even though there was a routine upgrade, the error was the minimum balance requirement just went up from $15,000 to $200,000. But that would never inflate the price of the crypto, the Apple at that point. It just strongly believe that the inflation of the price happened because Mr. Lead Payne has structured his program beta in a way that takes the advantage of this situation, and it inflates the price when there are no other sellers of Apple in the platform. So on that basis, we strongly believe that this is a unilateral mistake from the part of Mr. Lee Payne. And here, like mentioned, the traceable mistake that is in the case of AI versus persons unknown. Here, the commercial code granted proprietary injunction against those who have fraudulently extracted or misappropriated traceable proceeds of digital asset. This case can relate to our case because this means that here Mr. Payne has misappropriated this the cryptocurrency through a mistake in his programming. We believe that this is a mistake. The inflation of the price is a mistake from Mr. Lee Payne because he has structured his program in a way that it inflates the price when there are no other sellers of Apple in the market, Your Lordship.
Thank you, Counsel. I don't have any further questions. Does that complete the submissions that you wish to make before your co-counsel begins?
Yes, Your Lord.
Right. So perhaps we can hear from your co-counsel now with the remaining submissions, please. Miss Matat, do we have your co-counsel online?
Yes, Your Lord, she's here. Inas, could you please go with your submission?
Is she having any particular technical issues? If so, Inas, could you just notify me if that's the case? Perhaps by chat if your audio isn't working. I can't hear you. I don't think that anybody else has been able to. Counsel who are on the call, have any of you been able to hear Inas making her submission? Inas, I can see you now. Do you want to just try? I can see you now. Do you want to just try?
Can you hear me, Your Lordship?
I can hear you. It's not entirely clear. It's breaking up a little for me. But if you just try again in terms of just starting your submissions, and I'll see if it gets any better. If that would help, if you want to leave and try and rejoin the meeting, and we'll see if that rectifies the issues with the audio, please do so. remaining counsel who are on the call, if you just bear with us just a couple of minutes to try and see if Inas can rectify and resolve the audio issues that she's having. We'll just allow her time to rejoin.
Hello.
Oh, hello. I can hear you now.
Am I audible?
You are, yes.
My
Okay.
apologies, my lord. I was no.
That's all right. These things
My
happen.
lord, as it's already yes, all right. My lord, as it already been stated, my name is Inasa Jami, and I appear as a counsel for the respondents. My learned counsel has already dealt with the law ground, and I shall now be dealing with the jurisdiction. Now, if it may please the court, shall I proceed with my submission? It is a fundamental rule of judicial authority law. Under law number 12 of 2004, the jurisdiction of this case is clear, where in Article 5A, subclause 1, subclause B, state that any civil or commercial claims which arise from the contract, no matter its completeness, will be performed within the DIFC according to the express or implied terms of the contract. Further to this, if I may direct the court's attention to Article 7, Clause 3, it states that the executive judge at Dubai courts has no jurisdiction to review the merits of a judgment, award, or order of the courts, which in this case, the IFC. This stipulates that in this case, if Mr. Payne would like to take the case outside of the DIFC, he is still unable to have the relevant Dubai courts to handle it. Now, this point is also solidified in judgment made in Barclays Bank and His Excellency Hamad Sohail, where my lord, this case provides that this court stands on the UAE Civil Procedure Law 1992, or the CPC, is undisputed. It has no application on the DIFC and the DIFC proceedings, which are solely determined by the Judicial Authority Law. Specifically, they pointed out on how Article 5, Subclause A, Subclause 4 of the legislation is unique provision in the UAE which allows it to operate in one directional system to limit the DIFC jurisdiction, but not for other courts in the UAE. It does not prevent the court from ruling on its jurisdiction, but rather sets the limit. In relevancy to our case, it reinforces the stance of the court on the UCPL, or the UAE Civil Procedure Law, as it shows that the Dubai courts have no jurisdiction over the DIFC law. My lord, I will also begin by mentioning that the UAE Virtual Assets Law sets up the regulation of virtual assets or tokens through the establishment of VARA, which is Virtual Assets Regulatory Authority. However, VARA and the subsequent UAE Virtual Assets Law exclude any types of activities done within the Dubai International Financial Center. Rather, the DIFC uses rules and regulations set out by the DFSA, which is the Dubai Financial Services Authority, regarding virtual assets. In particular, the amendments made in Part 3 of DIFC Law Number 6 of 2021 make changes to the market laws of 2012. The following amendments mentions concerning the Article of 10 of market laws that the provisions in Part 2 of this law and the rules made out for that part shall apply to a person who has or intends to have units admitted to trading on an authorized market institution or security tokens of this matter that are units admitted to trading on an alternative trading system. May I put it to the court that this entails only investment tokens regulated under the DFSA, and such crypto or virtual assets transactions that are done within the firms that are unregulated by the DFSA. As such, the jurisdiction and laws applied to this case will be strictly that of regulations provided by the DFSA rather than the VARA or VARA. Now, to point from this case to reference, we have a case from this appeal or this Court of Appeal case. The question of jurisdiction was put into focus on the point of the Joint Judicial Committee's involvement and how it can change the factors related to the jurisdiction. Now, the facts of the case present themselves that if any parties wish to have another court, in this case Dubai courts, judge on their case, a petition must be made to the JJC or the Joint Judicial Committee, and they must notify the relevant courts of this to achieve a stay of court proceedings until the JJC has completed their judgments. Its relevance to our case is very apparent. If Mr. Payne wished to switch over jurisdictions and handle the case outside of the DIFC, then they need to first obtain a judgment from the JJC to do so. But in this case, however, nowhere in the facts is it present that Mr. Payne had attempted to do so whatsoever. Now, another case we have is Al-Khurafi and others and Bank Saracen. Now, the main aspect or issue of this case is the purchase of an estimated 200 million in structured instruments by Al-Khurafi family to meet a certain financial objectives. This purchase was made up of many different loans and borrowed money, most notably from the Al Ahli Bank in Kuwait and Bank Saracen. Now, the financial when the financial crisis that happened in autumn 2008, the investment portfolio created for the family was devalued. This meant that the family default on both purchases of a total 26.8 million, and its affiliates were to pay compulsory damages to the family as a result of selling inappropriate investment instruments. Now, the application of jurisdiction laws is present here in the case of Khurafi, that he had gone through the DIFC court despite the company being based in Switzerland. Now, the family had ultimately made negotiations, discussions, and signed agreements on the DIFC branch of the company, and as such was subject to the rules set forth in the jurisdiction. In fact, it is important to note that the branch was set up specifically to deal within DIFC, which means that any entity that performs transactions within the area are subject to the DFSA and the DIFC rules. So essentially, it is establishing that regardless of the company's original headquarters, so long as a transaction took place in the DIFC, it is subject under DIFC law. Now, and to conclude, we seek that the DIFC court therefore has jurisdiction over the claim against Mr. Payne, considering the grounds that have been mentioned already. Now, concluding to this, does your lordship have any questions?
I do, counsel. Thank you for your submissions. So my understanding. Oh, I'm getting an echo. I'm just getting an echo. I think that's gone now. All right. My question is simply this: your submissions are that the court shouldn't look at where either of the parties is domiciled, which you would have heard was the submission made by the appellant's counsel. That in fact, I should be looking at the correct jurisdiction being, in fact, where Mr. Payne is domiciled, which is Oman. If you can address me in particular as to how the court and I can be satisfied that this transaction comes under the jurisdiction and scope of the DIFC courts. Is your submission that I should be satisfied that the transaction took place in the node of the distributed ledger system that is contained or located in the DIFC, or is it that or is it your submission that the court shouldn't look because of principle at where individual parties are domiciled?
My lordship, thank you for your question. Because the jurisdiction or the transaction happened within the node of the DIFC, the jurisdiction clearly mentioned that they can only do the case within the DIFC and not outside, no matter where the sellers have been residing. So because the transaction had happened within the node of the DIFC, they have to consider the DIFC laws.
Council, was there a contract between the parties wherein the parties had agreed that the DIFC courts would be the correct jurisdiction in the event that there was a dispute?
Yes, my lord. If I understood your question correctly, in the judicial authority law, it clearly mentions that if the contract was done within the DIFC, then no matter its completance, they have to follow the DIFC law, and that the Dubai courts cannot handle the same case.
Thank you, Council. I don't have any further questions.
Thank you so much. May I proceed with the prayer, my lord?
Yes, you can do so.
My lord, wherefore, in the light of the issues raised, arguments advanced, and authorities cited, it is humbly prayed that this honorable court may be pleased to declare that the DIFC has jurisdiction over the claim against Mr. Payne, to seek of declaration that the disputed trade was void for a unilateral mistake, and pass any order, direction, or relief that this honorable court may deem fit in the interest of justice, equity, and good conscience. Thank you.
Thank you, Council. Can I ask if either yourself or your co-counsel have any further submissions to make on behalf of the respondent, please?
No, Your Lord.
Madam Lord.
Thank you. Similarly, can I just address the team for the appellant? I don't know if either of you would like to come back on any of the submissions made by way of rebuttal. If so, if you could just make yourself known to me with your video on and make the submissions you wish to do so, please.
Yes, my lordship. My opposing respondent made a statement regarding, just give me a minute. My lordship, there's been a glitch in my laptop.
I can see and hear you okay on my end. Can you hear me?
Yes, my lordship, I can hear you now. Yeah.
Okay, proceed.
My learned opposing respondent made a statement regarding unilateral mistakes, saying that it was the mistake of my party, Mr. Lee Payne, for which the error happened. I would like to say, according to the facts, Ms. Razi's program, which was called Alpha, was programmed in such a way that it's coded in such a way, if there are no other users offering to sell YAPL on the Clarity platform, they could buy YAPL. So does the opposing respondent have any statement?
May I proceed, my lord?
Yes, please do so.
Okay. With due respect to my opposite counsel, I do say that the statement of facts clearly say that our program Alpha is being programmed in a way that it buys Apple at the best possible price at any market condition. It is whether there are no other sellers or there are sellers in the market. It is set up in a way to buy the Apple at the best possible price. But your issue is that in Apple at the average price, but when there are no automatically inflates the price. And this particular characteristics of your program we conclude it as a mistake. And on that basis, we say that this is a unilateral mistake from the opposite party.
Thank you, Council. Henna, I have a message from you that you weren't able to hear that. Council, I don't know if you would be content just to, in brief, perhaps restate the submission that you just did, because I understand that counsel from the appellant team wasn't able to hear.
My lordship, I think it was a lag. I could hear her eventually. After the message, I could hear her. It was a lag.
Fine. Okay. Well, thank you for that. Could I ask if there are any further submissions arising from those from the respondents at all?
No, Your Lord.
Okay. Right. That then concludes the hearing. I have heard submissions from both parties. It will now be a case for me to go away and deliberate with myself about the submissions I've heard from either side. Thank you very much for all your efforts in relation to your written submissions that were well received, and your oral submissions today. This is the first time a moot court is being held in relation to matters concerning the Digital Economy Court. And I would encourage, no matter how you do in this competition this year, to come back again and grapple with these issues. They are particularly interesting, as I'm sure you'll agree, and they provide a lot of food for thought. So I wish you the very best of luck in this competition, and I hope to see you all joining again year after year, perhaps, as you continue through your studies. So thank you very much, and I wish you the very best of luck going forward. I will now leave this meeting, which you will be able to do as well at your end. So I will do that now and go and consider my marking for this round. So thank you very much once again.
Thank you, my lordship.
Thank you.
Thank you.
Thank you all.